Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. As we have made an announcement yesterday that we have come up with the new initiatives where we are bringing to you some of the practice questions as well with respect to the articles that are in news. So what is that you have to do? Like these initiatives, click on the subscribe button and also share it with your fellow aspirants as well. Let's look into the first question and the first article as well. Which among the following is not correctly matched? We have operation on one side and the country where Indians have conducted this operation basically to evacuate the Indians. Why? Because there has been a hostile situation created in that particular environment. So Operation Ajay, Israel, Operation Devi Shakti, Nepal, Operation Kaveri, Sudan, Operation Rahat, Yemen. The answer to this is Operation Devi Shakti, Nepal. Why have we taken this practice question? Because this article on the Hindu makes a reference to Operation Ajay, which is why we have taken this practice question. When we speak about operations, remember you have Operation Ajay where Indians are being evacuated from Israel. What is Israel currently facing? A hostile situation where people are being taken hostile because of the kind of conditions that are existing in Israel, and we have had issues between Hamas as well as Israel as well. So the environment and circumstances are not proper. So who has to take care of the Indians who are in Israel? It happens to be the government of India. So to evacuate all those Indians who are present in Israel, what we have is the government of India which has taken up this initiative called as Operation Ajay. So where is Operation Ajay being undertaken? It is undertaken by the government of India to evacuate Indians in the country of Israel, primarily because there are some hostile conditions that are presently existing in Israel. And whenever you read a newspaper article which has such patterns, you have to go back to the history books as well, where you have to understand that India has taken similar such measures in couple of other countries as well. For example, when we speak about Operation Kaveri, it has been taken place in Sudan where Indians were evacuated from Sudan. Similar such hostile conditions were prevalent. And we had Operation Rahat where Indians were evacuated from Yemen as well. But when it comes to Operation Devi Shakti, it is not Nepal, but instead it is Afghanistan. Yes, we did have India and Afghanistan match yesterday, so we thought let's make it a question out of that. So Operation Devi Shakti is when Indians were evacuated from Afghanistan when Taliban took over the power in Afghanistan. Immediately after United States of America withdrew from Afghanistan, Taliban took over the power. So many Indians were stuck in Afghanistan and many others also wanted to leave Afghanistan and move to some other countries as well. So in order to help the Indians evacuate from Afghanistan immediately after the withdrawal of US and the power ascendance of Taliban, we had Operation Devi Shakti that was taken up by the Indian government. So remember, Operation Ajay is the evacuation of Indians from Israel. Operation Devi Shakti is evacuation of Indians from Afghanistan. Operation Kaveri is evacuation of Indians from Sudan, and Operation Rahat is from Yemen. So these are some of the important pointers that you have to remember, that Operation Kaveri is the Indian government initiated operation to rescue 3,000 Indian nationals stranded in the war-torn Sudan, and then Operation Rahat when a conflict broke out between Yemeni government and Houthi rebels. Thousands of Indians were stranded. Yemen was inaccessible due to a non-fly zone announced by Saudi Arabia. India evacuated nearly 5,600 people from Yemen. So this happens to be the issue in news, and this happens to be the topic that is in news and how questions can be framed from the UPSC examination point of view. Now let's look into the next practice question and the next article as well. Operation Polo is related to annexure of Junagadh, Operation Against Naxalites, Police Action Against the Princely State of Hyderabad, Liberation of Goa. What is this Operation Polo all about? The answer to this is, this was a police action against the princely state of Hyderabad immediately after the independence. So we ensured that there was police action to take over Hyderabad immediately after independence. Why are we discussing about this particular question? Is because this article on the Hindu makes a reference to Operation Polo. So what is this Operation Polo that we are speaking about? Immediately after independence, we had many princely states in India. These princely states were given an option. Dear princely states, you can either join Pakistan or you can join India or you can become independent. Most of the princely states in India went ahead and they became an integral part of India. But there were three princely states which either wanted to become independent or they wanted to merge with Pakistan. We had Junagadh. Junagadh happens to be one of the princely state. Where was it? It was in the current state of Gujarat. Junagadh wanted to join Pakistan, but it was contiguous with India. So you have one particular area within Gujarat, and throughout that particular region in and around it, we had the Indian population, that is majority Hindu population, who wanted to stay with India, and even the people of Junagadh wanted to stay with India. It is only the king who wanted to join Pakistan, but then we had a mission and immediately Junagadh was taken over and it ultimately became part of India. Why? Because this particular area was not contiguous, it was not in continuity with the Pakistan which forms its border. So it was only a small pocket in and around it was India. People had become part of India, and these people within Junagadh itself wanted to be part of India. It was only the king who wanted to become part of Pakistan, and ultimately actions were initiated and Junagadh became part of India. Then we all know about the story of Jammu and Kashmir as well, where we have Raja Hari Singh and he wanted to stay independent, but there were non-state actors that were sponsored by Pakistan. They infiltrated India, and ultimately Jammu and Kashmir, three parts, one is defense, communication, and then with respect to the communication became part of India. So he signed a treaty, he annexed it, and ultimately over a period of time Jammu and Kashmir also became an integral part of India. Now the state that we have to discuss is with respect to Hyderabad. So what exactly happened with the princely state of Hyderabad? In the princely state of Hyderabad, we had the Nizam. Nizam wanted to become independent as well. So what does he do? He wants to become independent and does not want to become part of India. It is at this particular moment you had the communist forces, that is the Communist Party was also in the realm of the affairs at that particular moment in Telangana. They did not like it as well. They wanted to be part of India as well. People of Hyderabad also wanted to be part of India as well. In fact, we had then Home Minister Sri Vallabhbhai Patel ji, who also communicated to Nizam. He said, dear Nizam, see, the people of Hyderabad want to stay with India, but you want to be independent. This cannot happen. So the minute these kind of negotiations started happening between the Home Minister of our country with the Nizam of Hyderabad, something else was brewing in Hyderabad. What was it? You had Razakars. Razakars are the private army of the Hyderabad, that is the Nizam of Hyderabad. So these people start imposing bloodshed in Hyderabad. Large number of people were killed. That is when the Indian government decides that we have to take a police action and take Hyderabad under our custody. So who were Razakars? Razakars were the private army of the Nizam. They started creating a lot of ruckus and chaos in Hyderabad. There were bloodshed as well. So there was communist forces, the CPIM, so on and so forth. They also started supporting India, and the Indian government decides that this hooliganism and if this violence has to stop, we have to initiate a police action, and that police action initiated by the Indian government to take Hyderabad and under our control is what is called as Operation Polo. This is also called as Operation Caterpillar, but remember, Operation Polo is the police action initiated by the government of India primarily to take control of Hyderabad, and ultimately the Nizam signs off, he pushes off, and Hyderabad becomes part of India officially. That is what is called as Operation Polo. Now let's look into the next practice question and the next article for the day. This article says, article dash, that is article of what, of the Indian Constitution, makes provisions for the transfer of a judge including the Chief Justice from one High Court to another. Is it 143, 198, 222 or 234? The answer to this is 222 of the Indian Constitution speaks about provisions for the transfer of judge including the Chief Justice of one High Court to another High Court. What is this article speaking about? This article here is primarily speaking about transfer of a Manipur High Court judge, which is why we have taken this practice question. When we speak about the High Court judges, the High Court judges can be transferred from one High Court to another. Let's say, for example, we have the judge of the Karnataka High Court, who happens to be Alok Arade. He was present in the High Court of Karnataka. He was also seated in Court Hall number 2 as well. How do I know about it? Because I practiced before the Honorable High Court. So he was present in the High Court of Karnataka, and now he has been transferred to the state of Telangana, and he becomes the Chief Justice of the state of Telangana's High Court. So a judge from one of the High Courts can be transferred to another High Court. He can become the Chief Justice of another High Court, or he can be transferred as another judge in another High Court. Where do we have it? We have it under Article 222 of the Indian Constitution, which speaks about transfer of a judge from one High Court to another. What does it read? The President may, on the recommendation of a National Judicial Appointments Commission, referred to in Article 124A, transfer a judge from one High Court to another. So it is the President who will transfer it. So the recommendation will be given by the collegium, that is, the recommendation will be given by the Chief Justice of India on the consultation with the senior most judges, and ultimately this recommendation is sent to the President, and the President will make this transfer. So remember, if there is a question which asks you that it is the CJI who may make the appointment or transfer a judge, no, it is the President who will transfer a judge from one High Court to another, but the recommendation will be given by the Chief Justice of India. So when a judge has been or is transferred, he shall, during the period he serves after the commencement of the Constitution, he will get the salary, so on and so forth. So where is this article? It is in Article 222 of the Indian Constitution. So when we speak about the transfer of a judge, there can be a couple of aspects that we have to look into. What are these aspects? One, what if the judge does not want to get transferred from one High Court to another? So who has the locus standi to actually ensure that this particular judge is transferred or not? Whether I can file a case, whether I can say that this particular transfer, I mean to say general public, or it can be any other person. Is it the advocates? Let's say, for example, there are a number of advocates who voice their concerns that so and so judge should not be transferred from one High Court to another. This has happened in the case of High Court of Madras, where one of the judges were transferred from High Court of Madras to a court in the northeastern part. So many advocates did not want it as well. They also protested as well. So who has the locus standi? So when it comes to locus standi, it says in K. Ashok Reddy versus the Government of India that the locus standi is only for that particular judge. Can I oppose? No. Can you oppose? Not at all. Can another person or group of advocates, can they actually go on a protest and do all that? No, they do not have the power to do so. So the locus standi is only for that particular judge. If there is a judge A who is being transferred from the state of Karnataka, that is High Court of Karnataka, to the state of Telangana or to the state of Maharashtra, it is only judge who has the locus standi, and even that judge will not have all kinds of power, but only if the consent of the Chief Justice or this particular transfer order is not initiated by the Chief Justice of India. Only on that particular point alone that this judge would be able to question it, not on any other means. So in K. Ashok Reddy versus the Government of India, the locus standi is with respect to that specific judge who is being transferred. None of them, none of the other people have the particular locus standi to question it. And even the judge can question it only on the premise that this particular suggestion was not given by the Chief Justice of India. So basically it says that K. Ashok Reddy was Government of India basically goes on to say, not having emanated from the Chief Justice of India, only on that stance that the judge being transferred can question it, and the consent of the Chief Justice or the judge of the High Court is also not a necessity. Maybe they can seek the opinion, but whenever a judge is being transferred from, let's say, one High Court to another, they can seek the opinion of the Chief Justice of that High Court. Let's say it is the judge of the Karnataka High Court who is being transferred to the state of Kerala. In that case, there are two Chief Justices who are involved. One is from the state of Karnataka, the other is from the state of Kerala. So they can put out a viewpoint to both the Chief Justices, but is the recommendation required? Nothing of that sort. And also remember, the consent of a judge for his first or the subsequent transfer would not be required, which means to say when a person is being transferred from for the first time, is this consent required? No. He is being transferred to for the second time, is this consent required? No. So if he is moved from one high court to another, does he require does the Chief Justice have to take his permission? Not at all. So for the first time or even for the subsequent time, they need not have to seek the consent of that judge who is being transferred from one particular high court to another. And all these transfers are always made in the public interest. So it is in the public interest that is promoting the administration of justice throughout the country, making sure that there is efficiency in a particular high court, and they feel that this judge, if he goes to another high court, he will be able to create landmark precedents, or he would be able to deliver justice to the people in that particular region. So all transfers are made in the public interest. So the Supreme Court has clearly clarified that it is the locus standi of that judge only on the premise that it has not emanated from the Chief Justice of India. That is when it can be questioned, and all transfers are to be made in the public interest. This is what we have to understand with respect to this article. Now let's look into the next article. This article says civil servants plan to contest election goes awry with MP government's no to the resignation. There are two important points here. You are wanting to be a civil servant, so this is very important for you. There are two aspects to it. One is from the purely administrative purpose, that is we will understand the code, the rules, so on and so forth, and we will also look at it from an ethical perspective, which is important from your GS paper 4. How is that we are going to link this to the GS paper 4? In GS paper 4, once again, you also have the conduct of the civil servants. What is the conduct of the civil servants? I am an IAS or I am an IPS. I am serving for the government of India. I am now as the custodian and as an employee or the officer of the government of India, and all of a sudden I resign. When I resign, should there be a cooling off period for me if I have to join the civil service, if I have to join politics? Why? That is because when we speak about ethics, what happens? Let's say for example, there is a bureaucrat, and this particular bureaucrat, let's say he is posted in one of the districts in the state. For example, let's say for the sake of simplification, he happens to be a district collector, let's say in the state of Karnataka, in the district of Mysore, which happens to be one of the districts in Karnataka. What if this district collector is closely attached to one of the political parties when he is a district collector and IAS? So what would he do? He will start ensuring that a particular policy decision goes in favor of that political party. So whatever that political party says, he will be listening to it. And one of the major pointers when it comes to civil conduct and rules is non-partisanship. We should not have any partition, which means to say I should not be partitioned to one particular ideology. I should treat all governments as equal, all ideologies as equal. The constitution will become my Gita, my Bible and the Quran, and there is nothing called superiority of any other legislation. All that I have to seek and look into is to the Constitution of India, and my every action should be according to the Constitution of India. But what if I am a civil servant, I am being partitioned towards one political party or an ideology with an idea that if I am been seeking an ideology or representing one of the political party, they will give me an MLA ticket, they will give me an MP ticket in the next few years. Is it the right thing for an IAS to do or an IPS to do? No. This is where ethics comes into picture. So whenever there is an IAS officer, he also becomes the representative of the state. He will conduct number of activities as well. So during that particular period, when he is an IAS officer and he immediately resigns after a particular period of time, there has to be a cooling off period. What is this cooling off period? Let's say for example about 2 years. So you resign today, you have garnered attention, you have all the prestige and the aura that you have created for yourself. At least for the next 2 years, you should not be able to contest in any political party. You should not be given any political party's ticket as well, because in case you do so, you are favoring representing one of the political parties. So the conduct rule should be created in such a way that you are an IAS or an IPS officer right now, but if you decide to resign and ultimately go and contest within one of the political parties, you would not be able to do so immediately, but this cooling off period will ultimately stop you to become the functionality of that political party, and that is the ethical perspective of this article. That apart, we have to also speak about resignation. What is resignation? Resignation is that particular idea where you would draft an email or you would send a letter to your ministry or to the designated authority that, sir or madam, that I am resigning from this particular position. So you draft an email and you say that I am resigning from this particular position in so and so position in that particular district, and you would want to discharge from your services, that you would not want to continue with the services, is called as resignation. So resignation is a formal intimation. I am intimating the government of the state as well as the central government that I would want to leave from this particular designation or from this office, and ultimately specify the date from which you would not want to continue with this particular service. So where is it covered? It is covered under the All India Services Death-cum-Retirement Benefit Rules of 1958. In case I want to resign from my All India Services, which includes IAS, IPS and IFOS, that is the Indian Forest Service, in all these cases, where are the rules? It is in the All India Services Rules of 1958. Where do we see it? We have it under Rule 5, removal, dismissal or resignation from the service. And whenever you are speaking about resignation, remember, if you are voluntarily opting for it, will you be entitled to the pension? So if I am a person who is resigning, will I get the pension? No, I will not get the pension. But if it is the VRS, which is the voluntary retirement scheme, in that particular case, you may be entitled to the pension. But if I have done it voluntarily, that is, I have resigned from that particular position, I may not be getting the pension. And to whom must the resignation of an IAS officer be submitted? When it comes to the resignation, if it is the state government, if I am working for the state government, I will be representing and giving it to the chief secretary. And if I am on deputation to the central government, I am working for the central government, in that case, I should be giving to the relevant departments whomsoever I am working, and this will be ultimately, consent will be taken from the state governments, because you will also have the state cadre and the resignation may be accepted. What happens after the resignation is submitted? After the resignation is submitted, there are two viewpoints that will be considered. One is, do you have any of the cases that is being investigated by the vigilance department? If that particular vigilance department is checking whether you have any corruption issues, or you are involved in any of the scandals, or there is a corruption case against you under the Prevention of the Corruption Act, in those cases they may not take your resignation. And what if you have taken a particular plan of the government of India that you have gone to a foreign country, let's say for example for your further studies like Harvard, or for example Massachusetts, or any of the other technological companies where you are studying about the public policy. It is the government of India which has funded your program, so you are eligible and you are entitled to serve the government of India for a contract period of so and so as prescribed in that particular contract. Now if this resignation is submitted, the government of India will look into the contract terms and conditions and will only then accept it or reject it. So immediately after the resignation is submitted, the government of India and the respective states will look into whether this resignation has to be accepted or not. If it is accepted, you will be relieved from your services. If it will not be accepted, then in that particular case, you maybe have to continue with your services. So according to the general rule, whenever a resignation is given, it will be accepted by the government of respective states as well as the government of India, except in certain conditions. What are these? When a government servant who is under suspension submits a resignation, the competent authority should examine with reference to the merit of the disciplinary case pending against the government servant whether it would be in public interest to accept the resignation. As we just discussed corruption issues, in some cases resignations have been rejected because disciplinary cases were pending against the officers. In such cases, concurrence of the Central Vigilance Commission is also obtained, or you have signed a bond to serve the government for a specified number of years on account of having received specialized training, a fellowship or scholarship for studies as we just discussed, or let's say for example the government of India has invested a lot of money on you, you are posted in one of the departments which requires extreme specialization. So if your position is removed, you cannot have a new person coming up to that particular position immediately, because this requires a lot of expertise which you have garnered over a period of time, and the government of India has invested so much of time and money on you. So if it is such a critical position which will require such expertise, until and unless we have a new member coming in and we have relevant expertise for the same, only then resignation will be accepted from this particular person. So these are the ways and means as to how resignation will be accepted. And there will be a request for withdrawal of resignation shall not be accepted by the central government where a member of the service resigns from his or her service or post with a view to be associated with any political parties or any organization which takes part in the politics or take part or subscribe in it or assist in any other manner. Now what if there is a government officer, and if this government officer has given his resignation and now he does not want this resignation to be accepted by the government, but the government says that according to the rules, if you are engaged in political parties actions, you are constantly working with an organization which is against the government in that particular case may not give back the resignation and you ultimately stand terminated. The guidelines also say that if an officer who has submitted his or her resignation sends an intimation in writing withdrawing it before its acceptance by the competent authority, the resignation will deem to have been automatically withdrawn. So you have sent your resignation, but then the competent authority has not accepted it yet. Before that, you also send that let's revoke it, let's cancel it. In that case, again the resignation can be cancelled as well. This is what we have to understand from the resignation point of view. So what did we understand? We understood the cooling off period that is required for this bureaucrat to enter the political services, and at the same time we also understood the resignation rules that we currently have in our country. Now let's look into the next article. This article says United Nations Security Council reform is a song in a loop. The article here is speaking about the United Nations Security Council, the revamping of the United Nations Security Council. Why is it in picture? That is because we have President Recep Tayyip Erdogan of Turkey, who has recently said the Security Council has ceased to be the guarantor of world security and has become a battleground for the political strategies of only 5 countries. The UN Secretary General also said the world has changed, our institutions have not. We cannot effectively address problems as they are. If institutions do not reflect the world as it is, instead of solving problems, they risk becoming a part of the problem. Which is why we have this particular topic. What is the United Nations Security Council? It is charged with the maintenance of international peace and security, as well as accepting new members to the United Nations and approving any changes to the United Nations Charter. The Security Council has 5 permanent members. Who are these 5 permanent members? We have Russia, United Kingdom, France, China and United States. These people also are the veto power holders, which means to say in case there is a proposal that is made to the United Nations Security Council, if one of the permanent members, that is any of these countries, if they do not like the proposal, they can veto it, they can reject it, and ultimately that will not be fructified into an act. So Security Council also has 10 non-permanent members elected on a regional basis to serve 2-year terms. The body's presidency rotates monthly among its members. This article primarily speaks about what reforms has to be brought into the United Nations Security Council. Why? Because we have the veto power that is given to these 5 permanent members, and it is only these 5 permanent members who are present ever since 1945. We have changed a lot of times. We have changing conditions as well. New countries have become powerful as well. Then you have these countries which still retain that particular power, while many other countries do not have this power as well. So what we have to do is bring in new permanent members into the United Nations Security Council and revamp this entire United Nations Security Council structure is what is this article all about. So let's understand what is the author trying to say. Under the United Nations Charter, the functions and the powers of the Security Council are to maintain international peace, investigate any dispute between the countries, recommend methods of adjusting such disputes, formulate plans for establishment of a system of armaments, determine existence of a threat to the peace, call all members to apply economic sanctions and other measures not involving use of force, and to take military actions against the realtor. So the author in this particular says, who happens to be Shashi Tharoorji, he goes on to say why United Nations Security Council has to be revamped. That is because when you go back to the 1945, you had powers which won the Second World War and some powers which did not win the war. At that particular moment, you had very less number of countries, as many as 51 countries, which are part of the United Nations. But now we have more than 193 countries who are part of the United Nations, and United Nations Charter, the last time it was changed was only in 1965. It is not reflecting the changing times and the reality of today's countries as well as economy and the representation according to the continents as well. So when you go back to the 1945, for that particular moment it may have been right, but today we have changed circumstances. We have no representation from Africa, we have no representation from Latin America, and this is the major problem. So the author goes on to say that when you consider such countries where they have no representation, it is not reflecting today's reality. So there has to be a change that has to be brought to the United Nations Security Council. Let's take other example. Let's say, for example, in Asia, what we have is only representation of China, but we do not have representation of Japan, we do not have representation of India, and India being the largest democracy is not represented in the United Nations Security Council. Japan and India also contribute a lot as well. In fact, Japan and Germany have for decades been the second and third highest contributors to the UN budget, yet they are not part of the United Nations Security Council's permanent membership. Do we have any representation in Africa? No. And do we have any representation in Latin America? No. These countries are not even represented. They also represent a massive population as well. When these are the kind of things that exist, there has to be a reformation that has to be created in the United Nations Security Council. So what is the major issue? The major issue is India is not represented, Japan is not represented, Africa is not represented, Latin America is not represented, and many countries which have had made significant impact like Germany are not into this United Kingdom permanent membership. But what are the major impediments? The major impediments, as we all know, whenever we have to change the United Nations Charter, this will require 2/3 majority of overall membership, and that is how the change can be introduced. That is 129 countries out of 193 states will have to assemble, and they also have to ratify. This happens to become a major impediment because countries are not coming together. If we have United States of America which accepts it, Russia opposes it. If Russia accepts it, then United States of America opposes it. So we have China which may not accept the wordings of United States of America. This has become another major impediment. Added to it, if we take the example of Asia, we know for the fact that India is aspiring to become the next power. It wants to be a permanent member of the United Nations Security Council. But the impediment happens to be in the form of China and Pakistan. China does not want another power in Asia which is competing against it. Now let's take the example of Africa. What happens in Africa? We have Nigeria, we also have South Africa. If Nigeria is being proposed, South Africa may not accept it. If South Africa is being proposed, Nigeria may not accept it. Or let's take the example of Latin America. We have Brazil, we also have Mexico, we also have Argentina as well. If Brazil's name is being proposed, then you have Mexico and Argentina who are opposing it. In fact, you also have countries called as G4 which want to be part of the United Nations Security Council. Which are these G4 countries which are wanting to become part of the United Nations Security Council? Please put it on the comment section. At the same time, when you have G4 who want to become part of the United Nations Security Council, there are other countries which are opposing it, which is called as the Coffee Club. And this Coffee Club countries also have countries like Italy, which are opposing to this particular addition. So the author in this particular case goes on to say that United Nations Security Council has to be revamped, but then there are also major adults which also have to be changed, which also have to be reworked, says the author. It is this that we have to understand with respect to that article. Now let's look into the next article. This article here is speaking about women's quota. We are not going to speak about the women's quota, but all that we are speaking about is with respect to the one of the concepts that is mentioned in this article, which is called as the conditional legislation. What is this conditional legislation? When we speak about conditional legislation, why is it in use? That is because we know for the fact that the Women Reservation Bill was accepted and it was also passed in the Parliament. But when will it come into effect? It will be only in the year 2029 after the census has taken place. So what is conditional legislation? Conditional legislation basically is putting certain conditions as to when that particular act will come into implementation. For example, when it comes to the Women Reservation Bill, it will come into picture in 2029. Why? Because a census will have to be conducted, and only after a census is conducted, it will come into an application. So certain conditions are imposed in the legislation. Only when so and so conditions are met, that is when this law will take its effect, which is called as conditional legislation. That is what this article speaks about. So what is conditional legislation? Conditional legislation basically says that there are certain conditions within this act or in the legislation. Only when so and so conditions are met, the law will come into existence. That is what is called as conditional legislation. Then we have something called as executive legislation. What is this executive legislation? Executive legislation, or it is also called as delegated legislation. What exactly happens? Who makes the laws? It is the legislature. But what if the rules can also be drafted by the executive? That is what is called as executive legislation. It is also called as delegated legislation. Why? Because the law making ability or this particular power is given to the executive. So the legislature is delegating a certain of work to the executive, where they would be able to draft the rules. So the skeletal structure will be given by the legislature, but the rules, the muzzle to it, will be added by the executive, which is called as executive legislation or delegated legislation. Then we also have something called as the judicial legislation. What is this judicial legislation? Let's say for example, we have various high courts, for example, the High Court of Karnataka, or let's say for example, the Delhi High Court, or we also have the Supreme Court as well. In case how exactly their administrative mechanism will have to work, they come up with their own set of rules. These are called as the rules that the High Court or the Supreme Court comes up with, which is called as the judicial legislation. So the judicial legislation are the rules that they come up for their own administrative mechanism. Then we have something called as the colonial legislation. What is this colonial legislation? Colonial legislation is that particular legislation where the home country will not make any of the rules and regulations and the law, but some other foreign country which is currently running that particular country's government will make the rules and regulations and the law, which is called as the colonial legislation. So a colonial power will run the country's administration when they make the law, that is called as the colonial legislation. So what did we understand? Conditional legislation, Women Reservation Bill 2099, only when conditions are met it will come into practice. Executive legislation, delegated legislation, the legislature will give the skeletal structure, the executive will make the rules and add the muzzle. Judicial legislation and colonial legislation. Now let's look into the next article. This article is important from your GS paper 2, governance and polity. What is this article speaking about? It is speaking about a concept called as the guardian ministers. Who are these guardian ministers? It is a unique practice where in the state of Maharashtra. So where do you see the concept of guardian ministers? The answer to this is Maharashtra. The guardian ministers are appointed for every district and are meant to bring a minister's personalized attention to the development of that particular district. So every minister will be attached to one of the districts. So they personally will have to ensure the development takes place in that district. Why is it called as guardian district? Because a minister is attached to that particular district. So he becomes the guardian, he becomes the protector, he becomes the caretaker of that particular district, so that all the policy initiatives are ultimately taken up. Usually a minister in the state cabinet hailing from a particular district is made the guardian minister of that district. If a district has no representation in the state cabinet, then an outsider is appointed. Also, one minister can serve as a guardian minister for more than one district. The guardian minister is the ex officio chairperson of the district planning committee, which has to be constituted in every district as per law. What are the functions of the district planning committee? It will tackle patterns of common interest between panchayats and municipalities, including spatial planning, sharing of water and other physical and natural resources, integrated development of infrastructure and environmental conservation, both financial and otherwise. So it is the DPC which is expected to consider institutions and organizations as may be specified to achieve the set of objections, and what are the work that is being done. DPC will basically look at local resource sharing, area planning, solid waste and sewage disposal and other such matters which call for close coordination between panchayats and the municipalities. It is this that we have to understand with respect to this topic. Now let's look into the next topic. This topic says 3.21 lakh appeals pending with the information commissions. This can become a fodder for your mains answer writing. So this article says more than 3 lakh appeals and complaints are pending in 27 state commissions across the country, and the backlog has been steadily increasing. Of the 3,21,537 pending appeals, the maximum number was reported in Maharashtra. So this basically means you file an ITI and ideally they have to give you the information, but then they're taking a lot of time to give you this information. So in West Bengal, the estimated time for disposal is 24 years and 1 month, Chhattisgarh 4 years and 4 months, Maharashtra 4 years, Arunachal Pradesh 2 years and 11 months. So the time taken to dispose a complaint filed was computed using the average monthly disposal rate as well as the pendency. So this can become a fodder for your mains answer writing. So please take a look into it and give these numbers if there is a question on the RTA. It is this that we have to understand with respect to this article. In case you are liking these initiatives, please do like, subscribe to our YouTube channel and also share it with your fellow aspirants as well. This is it for today. Thank you for watching. All the best.